There's a major change happening to sex ed in Texas today. It's August 1st, 2024, and these are your headlines. Parents, you need to be aware, sex ed is now opt-out as Texas schools no longer require parents' approval before teachers expose their children to sex education. That's because a state law requiring parents to opt in for students to participate in sex ed expires today. Instead, parents must now opt out or else their kids will automatically see whatever sexual information teachers present in the classroom. And it definitely runs the gambit, as you can imagine, and we've reported on. Each school district decides what, if any, human sexuality instruction is offered to students. School board trustees who are elected make the final decision based on recommendations from a board-appointed Student Health Advisory Council, a SHAC. State law requires school officials to notify parents about the district's sex ed curriculum and to make the material available for public inspection. Last year, the Texas Senate passed legislation to make the parental opt-in for sex ed permanent, but, surprise, the House failed to vote on the measure before the regular session ended. The U.S. Fifth Circuit Court of Appeals has ruled that Texas's buoy barriers in the Rio Grande, well, they can stay in place, at least for now. Specifically, this week's ruling nullified an injunction that ordered the state to remove the buoy barriers from the river. The barricades repel illegal and sometimes dangerous water crossings in the United States. In early June of last year, Governor Abbott announced that the border buoy barriers would be deployed in the Rio Grande to assist in repelling illegal border crossings into the U.S. In response, the U.S. Department of Justice filed a lawsuit against Texas. They said the state had flouted federal immigration law and demanded that Texas remove the border barriers. Well, a federal district court granted the Biden administration's motion for a preliminary injunction, and the border barriers were ordered to be removed. A panel of judges from the Fifth Circuit also issued a split decision supporting the order, yet in January of this year, Attorney General Ken Paxton secured an en banc rehearing by the full Fifth Circuit. It's a lot of legalese. What does that mean? Well, now the Fifth Circuit has ruled that the district court misapplied the law in granting the preliminary injunction and that it abused the authority of the lower courts. The buoy barriers will remain as the case continues through the courts. In fact, the buoy barriers, if you'll recall, never left. And Governor Abbott said, "We fought to keep these barriers in the water, and with the Fifth Circuit's decision, that is exactly where they will remain. This fight is far from over. Texas will continue to defend our constitutional right to secure our southern border and to keep our state and the nation safe."
Hey folks, Chris Salcedo here. I've got something special for you, the Salcedo Storm podcast. As your friendly, liberty-loving Latino, I bring you a mix of engaging discussions to help us fight for our state and our conservative values. It's the perfect way to stay informed and engaged in what's happening around you. So, what are you waiting for? Don't miss out on the storm of information and entertainment coming your way. The Salcedo Storm podcast, available wherever you get your podcasts.
An unnamed fugitive from Peru is currently in the custody of U.S. Immigration and Customs Enforcement after entering the country illegally through Eagle Pass right here in Texas and being released into the country. Now, the Peruvian national was apprehended several times in the past. U.S. Border Patrol first arrested the national on January 7th of 2011, so over 10 years ago, after he unlawfully entered the U.S. near McAllen, Texas. He claimed to be a Mexican citizen and was granted a voluntary return to Mexico. Border Patrol officials later arrested the Peruvian national again on January 14th, 2011, after he unlawfully re-entered the U.S. near McAllen. This time, he claimed to be a Guatemalan citizen. On February 11th of that same year, the U.S. Citizenship and Immigration Services served the Peruvian national with a notice to appear before a Department of Justice immigration judge. On April 25th of 2011, the judge ordered him to be removed from the U.S. and sent back to Peru. That's where the story ends. No, it's not, because Border Patrol arrested him again on September 3rd of 2022, 11 years after that, after he unlawfully re-entered the United States near Eagle Pass, in which a reinstatement of a prior removal order was issued and his custody was transferred to ICE's enforcement and removal operations in Laredo. On September 6th, they enrolled the Peruvian national into the Alternatives to Detention program and released him on an order of supervision. Argentine authorities currently are seeking custody of him to serve a prison sentence stemming from his drug trafficking conviction in Argentina. According to ICE, deportation officers with ERO's Boston's Hartford field office arrested the Peruvian fugitive on July 25th in Hartford. He remains in ERO custody. For more of today's stories, go to TexasScorecard.com.